You're listening to In the Balance, an Iowa Judicial Branch podcast. Welcome back to another episode of In the Balance, Iowa's Judicial Branch podcast. This week, we are going to take a step outside of the Judicial Branch Building, figuratively speaking, to explore the whole of Iowa's statewide court system. Today, we are going to briefly explore the structures of Iowa's trial and appellate court systems and how they operate in unison to provide open and accessible courts where Iowans can seek resolutions to their disputes. Iowa's courts have been operating for more than 175 years. When Iowa courts were first established, Iowa was mostly uninhabited grassland with scattered settlements along the Mississippi River. On June 12, 1838, Iowa was declared a territory. And with this declaration, Iowa's territorial justice system began, with a handful of justices of the peace and 3 Supreme Court justices who presided individually over trials in the district court and as a group for appeals. By 1846, Iowa became the nation's 29th state, and the Iowa Constitution of 1857 endures to the present day. Today, nearly all cases begin in the district or trial courts. As we have 99 counties in Iowa, you would expect 99 district courts, 1 for each county. Lee County is the outlier and the only county with 2 courthouses, known as Lee North and Lee South, giving us an even 100 district courts. Those 100 district courts are grouped into 8 judicial districts for administrative purposes. Each district is headed by a chief judge who is selected by the chief justice. These district courts have general jurisdiction over civil, criminal, juvenile, and probate matters. These are the courthouses where people file lawsuits. Prosecutors file criminal charges. Trials take place with lawyers providing evidence, witnesses testifying, and juries deliberating or judges entering judgments. If you are a fan of courtroom dramas, the likes of Law and Order, Matlock, Suits, Night Court, and others, those courtroom scenes are reminiscent of district court trials, if on some occasions the shows remain over-dramatized. In reality, many district court cases in Iowa settle before going to trial. Of the cases that do go to trial, some are decided by a jury, but the majority are bench trials, with the judge presiding over the case entering the verdict and judgment. Depending on the case that comes before the court, one of 4 types of judges may preside over and enter a judgment. A magistrate has jurisdiction over simple misdemeanor cases such as minor traffic violations, county and municipal infractions, and small claims. An associate juvenile judge is limited to hearing juvenile court cases such as delinquency, children in need of assistance, termination of parental rights, and adoption. District associate judges have the same jurisdiction as magistrates, with the added authority to hear serious and aggravated misdemeanor cases, civil suits where the amount at issue is $10,000 or less, and juvenile cases. Lastly, district court judges are able to hear and enter judgments on all district court cases, no matter the issue. All of the cases brought to the district court begin with citizens, or in criminal cases, the state. Whenever there are people involved taking opposing positions in an argument, someone is bound to be dissatisfied by a judge or jury's decision. So, what is a dissatisfied party's recourse? They can apply for an appeal. The way I illustrate the appellate courts to the groups of students who tour our building each year is like this. It's a Friday night, and you want to stay over at a friend's house after the home football game. You go to Dad to make your case. He listens, pauses, and rules no, listing his reasons. What do you do next? You make your case to Mom. You present all of the same evidence, maybe even listing the reasons your dad ruled no in order to build a better counter-argument. Then you wait, patiently, for the final decision from the parent of last resort. This may seem like a silly, simplistic representation of Iowa's appellate system, represented in this example by mom, the parent of last resort. Yet, it's an experience most of us know well. An appeal is to seek a higher court review of a decision from a lower court, in this case, the district courts. Iowa has two appellate courts, the Iowa Court of Appeals, which is an intermediary appellate court, and the Iowa Supreme Court, the highest court in the state. The Iowa Supreme Court has existed in some capacity since 1838 and has seen changes over the years. It began with 3 justices, grew to 9, and is now comprised of 7 justices that sit in bank, or altogether, to hear and decide cases. The Iowa Court of Appeals was created in 1976, more than a century later, to help with the growing appellate caseload. It began as a 7-person bench and is now a 9-member court that sits in random panels of 3 to hear and decide cases. Why do appellate courts have more than one judge or justice? The basic concept of an appeal is that difficult legal questions are decided by a group of judges, rather than merely substituting the opinion of one appellate judge for that of one trial court judge. All cases seeking an appeal are sent directly from the district court to the Iowa Supreme Court. Out of the 2,000 appeals justices receive each year, they retain an initial 50 on average, sending the remainder to the Court of Appeals to review and then to affirm or deny the lower court's decision. If a case is decided by the Court of Appeals, but a party still disagrees with the decision, the party may apply for further review by the Iowa Supreme Court, the court of last resort. In addition to the original 50 cases the Supreme Court retains each year, they take an additional 50 or so further review cases from the Court of Appeals. In total, the Supreme Court rules on 100 or more cases each year, as well as attorney disciplinary cases, and the Court of Appeals rules on about 1,500 cases per year. While we may be familiar with the settings of a district or trial courtroom scene, appellate courtrooms and procedures bear very little resemblance. There is no jury box, no witness stand, and multiple judges. In Iowa, parties in an appellate case submit written briefs with all of their arguments and legal research to substantiate their claim. They can then request to present their case before the court with oral arguments. The majority of attorneys request to appear before the Court of Appeals or Supreme Court in order to drive home their argument and answer the many questions justices may have. Unlike a trial court, where a judge hears evidence and presides over a jury, the judges of the appellate courts come prepared with questions and research of their own to try to better understand each party's argument. And most unlike a district trial, which may last a day, week, or even months, attorneys arguing before the Supreme Court are given a total of 35 minutes and just 25 minutes in the Court of Appeals, with much of that time spent answering rapid-fire questions rather than reciting their carefully researched and organized notes. One could say it is not for the faint of heart. After an argument is concluded and is submitted to the court, it takes, on average, 90 days for the appellate courts to publish an opinion or decision. The court can affirm the decision or order of the lower court, or reverse or set aside the decision or order. The court may also remand the case back to the lower court with instructions, such as instructions to hold a new trial. An appellate judge or justice who disagrees with the majority opinion may write a dissent that explains why they disagree. A justice who agrees with the result, but not necessarily for the same reasons, or to emphasize certain reasoning, may write a special concurrence. While parties in a Court of Appeals case can seek further review from the highest court, the decision of the Iowa Supreme Court is final. You've been listening to In the Balance, an Iowa Judicial Branch podcast hosted and produced by me, Marissa Gaal. If you would like more information about Iowa's courts, you can visit www.iowacourts.gov. You can also follow the Iowa Judicial Branch on Twitter and YouTube at Iowa Courts. This episode of In the Balance is now adjourned. Until next time.